we can start with the judges present in this particular round. I would request the judges to turn on their camera and start the rounds.
Hello, my name's Sushil Balara. I'm one of the judges. I'm a practicing barrister in the United Kingdom. I haven't spoken to my other colleagues who are judges, so I don't know who's online. Can I just check?
Okay, I'm Dr. Badruddin.
Sure, sir.
Do you hear me, please?
Yes, I can. Although no, I can't. Sorry, Mr. Badruddin, are you judging?
Yes.
Okay.
Okay.
Hi, Sushil. I am the third judge, Setu. How are you?
Nice to see you. Hello.
Yeah. I think we are the three judges.
We're the three judges. Good. Nice to see you all. I don't know who's going to be chairing this as judges. I mean, I don't know if there's any protocol to be followed, but I was just going to ask the parties just to introduce themselves. So I have a record as to who's representing who, just to clarify before we start. But if that's okay with you, both judges.
Yeah.
Yeah, okay. Let's start.
Yeah.
Sir, I'm Shivam Agarwal. I am the senior counsel for the defendant and I represent the team Gujarat National Law University, Gandhinagar from India.
Okay, so you're senior counsel for the defendant, yeah?
Correct. Shivam, yes.
Okay. Can I just check who's senior counsel for the claimant?
Hello, Your Honors. That would be me. I'm the senior counsel for the claimant.
You're senior counsel for the claimant, okay?
Yes, Your Honor.
And can I just check who's junior counsel for the claimant?
Well, junior counsel for the claimant is Kekayo Joseph. Let me see if she'll turn on her video. She's right next to me. Okay.
She's next to you, is she? Okay.
Yes, she is.
Okay. And junior counsel for the claimant?
That is the person that's next to me. The one.
Oh, you're junior counsel. Okay. And junior counsel for the defendant?
My teammate is junior counsel for the claimant.
Okay. So Chitraki, you're junior counsel for the defendant, yeah?
No, sir. I'm from
I think Suprava.
Yes.
Suprava. Sorry, the names got jumbled there. Suprava. You're junior counsel for the defendant. Right, got it. Okay. Sorry, the screens get shuffled around in terms of names. So just trying to
yes, I understand. There's a little bit of shuffling going on. Sorry to interrupt the judges. I'm there to help assist with respect to any tech issues. I'm representing the organizing team.
Okay. Perfect. So Badruddin and Setu, I'm ready to start by hearing the senior counsel for the claimant, unless you have anything to share with them.
No. I think we can start with the claimants, the senior claimant, the senior counsel.
Sorry. Before that, we should evaluate your time. You have 45 minutes. You have 45 minutes.
Yes, Your Honor. I intend to argue my first points for.
Before that, sorry. Before that, please evaluate your time for you as a senior claimant.
Okay. Yes, Your Honor. As the senior claimant, I will use 18 minutes for my arguments.
18.
And reserve 18, and reserve 5 for my rebuttals.
Okay, and for the junior claimant?
And the junior claimant will use 17 minutes for her arguments and reserve 5 for rebuttals.
Okay, let's start. Okay.
Thank you very much, Your Honors. Your Honors, good evening. My name is Richard Felix Uche. I am the legal representative of the claimant, Ms. Artemis Ashotea, in the case before this court. Your Honors, the case before this court is a claim brought by the claimant, Ms. Artemis, against the defendant, Solar Dream Incorporation. And a brief summary of the facts of this case highlights that the claimant paid a certain amount of money to the defendant as consideration for her participation in the Stars Aligned retreats, and the defendant under the agreement was mandated to comply with certain obligations towards the claimant which the defendant did not, thus necessitating the claim before this court. Your Honors, I will address this court on the first issue, which is Solar Dream's liability to Ms. Ashretea in tort and for breach of contract. Your Honors, it is the claimant's firm submission on this issue that the defendant is liable to the claimant both in tort and for breach of contract. And our submission will be put forward before this court on 2 grounds. First, Solar Dream is liable to the claimant for negligence. Second, Solar Dream breached his contractual obligations to the claimant under the agreement. On our first ground, Solar Dream is liable to the claimant for negligence. Now, Your Honors, the thought of negligence is outlined in Article 17, sub 1 of the DIFC Law of Obligations, which states that the defendant is liable in negligence to the claimant if and to the extent that first, the defendant owes a duty of care to the claimant. Second, the defendant breached his duty of care to the claimant. Third, the defendant's acts or omissions in breach of his duty of care to the claimant cause loss to the claimant. Now, Your Honors, paragraph 7 of the Moot Facts depicts that the defendant did owe a duty of care to the claimant, and this duty arises out of the natural contractual relationship between both parties, where the defendant was supposed to, where the defendant promised a safe and secure flight experience, and the claimant, our client, paid a considerable amount of money as consideration for same. Again, Your Honors, this duty of care also arises from the common law principle of occupier's liability as expounded in Article 23 of the DIFC Law of Obligations, which highlights that the defendants as occupiers of the premises were owed the claimant a duty of care to ensure that the claimant as a visitor to those premises were reasonably safe for the duration of her visit to their premises. Your Honors, the DIFC Small Claims Tribunal, sorry, Your Honors, is there a question?
No, okay, you can go.
Thank you very much, Your Honors. Your Honors, the DIFC Court of First Instance.
By the way, sorry, by the way, my colleagues, you can ask at any time. Huh?
Oh, thank you. Your Honors, the DIFC Court of First Instance in the Faisal Babu Muakat versus Expresso Telecom Group Limited case, citations 2023, DIFC Court of First Instance 008, rightly observed that the existence of a duty of care depends on the criteria set out in Article 18, sub 1 of the DIFC Law of Obligations. Now, Your Honors, this article provides that the defendant at all times had a duty of care if it is reasonably foreseeable that their actions could cause harm or loss to the claimant. Your Honors, in light of this, it is indeed not out of place to state that the natural and foreseeable consequence of embarking on a space flight without first obtaining and verifying the test results of all passengers and clearing them as fit for such space travel is the heightened risk of undetected diseases like the Vulcan virus spreading among passengers and crew, which, according to paragraph 13 of the note, is exactly what happened in the facts of this case.
Hello, Counsel, can you hear me?
Yes, Your Honor.
Yeah. Counsel, you are talking about the negligence from the part of the defendant. Is there any contributory negligence from the part of your claimant as well?
Your Honor, I can hear you. You're breaking up.
I think his connection's a bit shaky. I think.
Okay.
I think is he gone?
Yeah, I think let's just wait for him to come back.
Let's wait.
But you should do not.
Yeah, he's coming back. Yeah, I guess.
Okay.
Hello,
Yes,
Counsel,
Your
can you hear me?
Yes, Your Honor.
Yeah. You were explaining about negligence on the part of the defendant. Is there a contributory negligence on the part of the claimant because with regard to the medical details provided by the claimant when she was supposed to explain her medical issues?
Sorry, Your Honor, there was an echo. Can you just repeat your question?
I was asking about the contributory negligence from the part of the claimant because of which all these might have happened. So you were discussing about the negligence from the part of the defendant. So can you explain the reason why her negligence could have been the cause for the whole issues?
Can we explain?
Yeah, please.
Sorry, Your Honor, I think I agree. Can we explain what to the court?
Pardon?
I didn't quite get your question. Can we explain what to the court?
Counsel, you were explaining about the negligence on the part of the defendant, okay, regarding the test or medical test that was undertaken. There is a contributory negligence on the part of the claimant, which could have been the cause for all these issues as well, with regard to a medical condition. Can you explain on that point?
Oh, thank you very much, Your Honor. Your Honor, it is our submission that the claimant is not contributory negligent because first we must understand the duty to disclose in contemplation of the agreement between both parties. Now, Your Honors, clause 5.2 places an obligation on parties to disclose any conditions or potential medical conditions or symptoms which may hinder their ability to participate in the space flight. Now, Your Honors, we would like to remind this honorable court that on 2 different occasions, the claimant had passed all the physical examinations and medical examinations placed by the defendant. So there was no reasonable belief that the headaches that she has experienced and lived with for the past 5 years were a medical condition that would affect her participation in the space flight.
Can I thank my friend for his question, but your client ultimately doesn't disclose that she's been suffering for headaches, chronic headaches, for quite some time. So, in your opinion, do you think that that is a material non-disclosure, or do you think it wouldn't have made a difference anyway? What's the claimant's position on the non-disclosure?
Thank you very much, Your Honors. The claimant's position on her non-disclosure and whether it was a material fact that would have been necessary for the defendant is that it was not. Your Honor, would like to remind this court that paragraph 6 of the Moot Fact highlights that the claimant had visited several medical professionals over the past 5 years, and in all these visits, the medical practitioners that she had visited failed to diagnose her headaches as a medical condition. Therefore, it is within her reasonable belief that such headaches that she has had for the past 5 years and had not been diagnosed was not a material information that she should have disclosed to the defendant.
But she has specifically said that she purposefully didn't mention her issues, chronic illness. She purposefully didn't do that because if she had actually specified the same to the defendant, she might not have been taken for the space flight. She has specifically said that. So she knew what she was doing.
Thank you very much, Your Honor. Your Honor, I would like to draw the attention of this court to the fact that just like the defendants, our client did not know or believe that her headaches were a medical condition, which is why she subjected herself wholesomely and willingly to all the tests conducted by the defendants. In spite of this, they on their own part were also unable to detect or diagnose her chronic headaches.
Okay.
May I proceed, Your Honors?
Please.
Thank you very much, Your Honors. Before your questions came in, I was addressing this court on the existence of a duty of care on the defendant based on their contractual relationship. Now, I'll go ahead to show how they breached this duty of care, conforming to the second element of the tort of negligence. Now, for the defendants to have breached their duty of care to the claimant, it must be shown that they fell short of the standard of care expected of them as space flight operators, having regard to the likely seriousness and probability of injury to the claimant, as highlighted by Article 21, Sub 1 of the DIFC Law of Obligations. Your Honors, the defendant's actions in first, not conducting COVID tests on the claimant and all other passengers before putting them in a single quarantine facility was a breach of their duty of care to the claimant, as the Moot facts depict in paragraph 9 that our client only started experiencing these severe headaches, which later returned to a dull ache during the second week of the quarantine. Your Honors, unsurprisingly, this falls in line with medical statistics, which states that individuals who come in contact with carriers of the COVID virus begin showing symptoms within 5 to 10 days. So, Your Honors, our client's second week of quarantine exhibiting symptoms, 5 to 10 days medical statistics. Second, the defendant in refusing to obtain the PCR test result of passengers before greenlighting takeoff for the space yoga mats was also in breach of their duty of care to the claimant. As Your Honors, medical statistics have shown that the PCR test results would have been a more accurate way of detecting the COVID virus, and Your Honors, the defendant's actions depict a flagrant disregard for all medical guidelines regarding space flights, as the standard of care expected of air transport companies is one of the highest standards of precaution and vigilance. Therefore, Your Honors, their actions constitute a breach of the duty of care towards the claimant. Now, in showing this court how their actions are in conformity with the third element, which is the damage caused to the defendants. Your Honors, in estate of William Martin versus Southwest Airlines, the Maryland District Court stated that in situations where employees were not effectively screened for diseases, the employers were to be liable as they owed a duty to enforce precaution. Your Honors, conclusively, the breach by the defendants was the direct cause of harm or loss to the claimant, as it is our submission that the defendant's negligence led our client to contract the COVID virus, not just jeopardizing her health, but also the symptoms rendered her unable to participate in the Stars Align Retreat activities, which of course was a fundamental aspect of the contract between the defendant and the claimant, as our client had paid valuable money for same. Thus, Your Honors, in conclusion, we so submit that the defendants were liable for breach of their duty of care because their actions could be seen to cause loss to the claimant, and it did cause loss to the claimant, proving causation. Your Honors, on our second ground, Solar Dream breached its contractual obligations under the agreement between both parties. Now, it is our submission that the defendant's actions.
It's frozen again.
Okay.
Oh, now the time is going. Okay, that one is showing now. Can I have that one? I apologize for the momentary interruption. I was kicked out of the platform. I had to join on another laptop. Your Honors, before I was kicked out, I was arguing that the defendant's actions towards the claimant constituted a non-performance of their contractual obligations towards the claimant. Your Honors, Article 77 of the DIFC contract law states that non-performance is the failure by a party to perform any one or more of his obligations under the contract, including defective performance or late performance. Now, Your Honors, general law of contract is guided by certain elements. One of such elements is consideration. Now, under the terms of our contract, our client was to participate in the Stars Align retreats, where she was to record space yoga sessions and upload same to her YouTube channel. And she paid a valuable sum of $7.5 million as consideration for this. And the defendant, in turn, was supposed to ensure that our clients benefited from the activities of these Stars Align retreats. Your Honors, once again, I reiterate that this formed a fundamental aspect of the contract between both parties, as it goes to the root of the contract, and where our client was unable to enjoy the retreats, she was deprived of value her money. Thus, the defendant's actions in depriving her constitutes a non-performance of their obligations. Yes,
Counsel? Yes. Does the contract specify anything about the?
Sorry.
Can you hear me?
Yes, I can hear you now, Your Honor.
Yes. Does the contract talks anything about the videography or a permission to do a videography of the trip, or does it give any special allowance for your claimant that whatever any guarantee that she will be able to properly take all the videos and everything in the contract? Is there anything about the? Yeah.
Thank you very much, Your Honor. Your Honor, paragraph 7 and 8 of the contract highlights that the defendants and the claimants were engaged in a discussion where the claimant made known her expectations from the retreat to the defendants, and the defendants were in reasonably contemplation of this. Also, the clarification to the Moot problem as sent in by the organizers also states that the defendants were fully aware that she intended to record her space yoga sessions and upload them on her YouTube channel.
But nothing is there specifically in the contract. There is
so
nothing
Your Honor, your
specific.
question is if it is provided. Oh, thank you very much, Your Honor. Your Honor, it can as well be said to be an implied term of the contract, because it was in furtherance of this space in furtherance of these records of YouTube videos that our client was induced to contract with the defendant.
Can you help us with this aspect, please? As I understand it, your complaint is paragraph 15, the decision to proceed with the flight despite incomplete test results. So
Yes,
just
Your
help
Honor.
us with this on causation. If they'd waited for the PCR test, wouldn't they have then said to your client, well, you can't join the mission? And so wouldn't she still be in the same position as she is now?
Thank you very much, Your Honor. Your Honor, it is our submission that if they had waited for the PCR test results and they came back positive for the COVID virus, then our client wouldn't be in the situation that she is now, because the defendants would take actions to help her overcome the COVID virus and reschedule a flight for her. However, they did not wait and they took off, and she ended up being positive, and she has suffered loss because she can no longer participate, and she has also contracted the virus without proper medical attention. May I proceed, Your Honors?
Thank you.
Thank you very much, Your Honors. I'll now briefly outline the other clauses of the agreement that the defendant was in breach of. Clause 5 highlights the defendant's obligation to ensure proper medical evaluation of passengers in line with industry best standards and practices. Our first argument and our first ground shows that the defendant obviously was not in compliance with this, as their deficient medical protocols led our client to contract the virus. Again, clause 7.1 mandates the defendant's strict compliance with certain requirements concerning spaceflight operator safety protocol. Article 4.4.2 of the United States Federal Aviation Administration Regulation on Spaceflight Safety provides that spaceflight participants must undergo a medical consultation proximate to space travel, which must be conducted by a physician with training and experience in aerospace medicine. Your Honors, an interrogation of the facts of this case show that the defendants contracted the nurse who conducted the cursory medical examination on the morning of the spaceflight. It was done short notice. Your Honor, this shows that the defendants had no clear intention to observe the provisions that set out in the article and regulations so stated before this court. Your Honors, again, the defendant was not in compliance with his obligations when it greenlighted takeoff before accessing the results of the PCR test, which ultimately showed our clients had COVID. Therefore, Your Honors, in light of these arguments, we need to show this court how the defendant is liable in tort for breach of contract and liable in tort for negligence and under contract for breach of contract. And these instances have caused actual and potential loss to the claimants, some of which we will outline before this court. First, the defendant's breach disabled our clients from participating in the retreats and caused her to lose the entire sum of money paid, as well as other incidental benefits. Second, the projected earnings and incomes our client would have made from uploading the YouTube videos. Third, the medical costs incurred by our clients by her contraction of the virus.
Sorry, your time is finished. I add you 2 minutes for the network issue.
Oh,
still you
thank
have
you very much. Thank you very much, Your Honor. We appreciate the magnanimity of this court. Your Honors, we are outlining some of the damages that have been caused to the claimants by the defendant's breach of contract. The third were the medical costs incurred by our clients by her totally avoidable contraction of the Vulcan virus. And lastly, non-economic damages for the emotional distress and reputational harm caused to our clients for not just contracting the virus, but also failing to deliver on the widely advertised space yoga videos on her YouTube channel. Your Honors, the claimant therefore is justified in seeking damages to the tune of $15 million due to the severity of these breaches as they went to the root of the contract. Therefore, we urge this honorable court to uphold our claim, grant our reliefs, and resolve this issue in favor of the claimant. Thank you very much for your honors. With this, the case rests. Thank you.
Thank you. We'll move now to the senior defendant. Who will be the senior defendant?
I'm the senior defendant. I'm Shivam. I'm representing Gujarat National Law University.
Okay, you're welcome.
I just want to confirm whether I'm audible and visible properly.
Yeah, okay. We hear you and you are visible.
Okay.
Could you allocate your time, please? You have 45 minutes.
Correct. I'll be dealing with the defense to the claim in first 17 minutes. I reserve 5 minutes for the rebuttals. Okay. Similarly, my co-counsel Superva Sahu will be speaking for 17 minutes for her submissions and reserve 5 minutes for the rebuttals. And we reserve overall 1 minute for the plus minus of the total timings.
Okay, thank you.
I'll start?
Yeah, come on.
Good evening and good afternoon to everyone sitting at the different corners of the world. I am Shivam Agarwal, representing Team Gujarat National University. Greetings to this honorable court. Your honors, I am the counsel representing the defendant, the Solar Dream in the present case. If your honors do not have any preliminary questions, I would like to brief your honors with the special datelines which are so important to be understood in the present case before I make my submissions. So, if I make initial submission regarding the dates, the most important date comes to the 15th of February 2024 is the date which was originally scheduled for the Space Yoga Met. The most important date comes to the 10th February 2023 is the date when the claimant, who is Artemis in the present case, purchased the tickets for this Space Yoga Met trip. Now, most important part comes is the 1st February 2024 when the claimant came to the Dubai with a layover in New York. This is the first day when the claimant came to Dubai with a layover in New York, and from this day, the quarantine period for the 2 weeks before the spacecraft launch has already started. On 14th of February 2024 is the date when when my client already gave a green signal to the capsule to go off, and 15th of February 2024 is the date of the flight. Is the date of the flight. The point here to be noted is here on this date, the claimant, who is the Artemis, started suffering from severe headache and she also started feeling a tiredness. And she breached clause 5.2 and 5.3 by not informing the defendants about the changes in the medical conditions. So these are the some few important date sheets which I wanted your honors to be briefed about. Now, when I move to the submissions of the argument on behalf of the respondent,
Counsel, can I just pause you for one moment? Forgive me.
your honors,
None of that is actually referred to in your skeleton.
your honors.
Your skeleton argument doesn't set out this particular timeline and this layover. What's the relevance? I mean, it's not in the skeleton, so I'm just wondering what the relevance of it is at this stage.
Your honors, the limited word limit of the skeleton arguments doesn't allow me to put this date sheet. There were only 1500 word limits which I could use in the skeleton arguments. So I am free to use the date sheet in my oral arguments as per the instructions of the Moot code organizing. So because of the limitations of the word limit, I could not put everything in my written submissions of the skeleton argument. Henceforth, I am making the oral submissions. Just to brief you about the timeline, when was the quarantine period started, when was the capsule to be started, and when was the ticket purchased.
So it's quite an important chronology, though, from your side. So it should have been mentioned in the skeleton. I mean,
just because of the limitation of the words, we could not mention in honors. I apologize.
All right, carry on, yeah.
So to move with the further submissions of my argument, I would like, in the due course of my submission regarding the breach of the contract and the tort, I would like to make my submissions into 5 limbs. One is the duty of the care and the standard of practice. Second is the reliance on the lateral flow test which we did. Third is the claimant's pre-existing conditions of headache. Fourth is the mitigation efforts done by the defendant, which is my client. And fifth is about the damages. When I move to the first arguments about the duty of the care and the standard of practice, it is a humble submissions from the defendants that the defendant, which is the Solar Dream company, fulfilled all its duty of care by adhering to the industry standards and following the recommended pre-flight medical protocols. These protocols included the medical examination, lateral flow test, PCR test conducted on the day of the launch. This approach aligns with the well-established principles of duty of care.
Counsel, you just mentioned that you have done all the medical examination which is required to be done before the launch. But unless and until the results are out and results are checked in, what is the whole point of doing the medical test before the launch? Unless you actually get the results and which you can decide whether the astronauts or the travelers can travel to the outer space.
Your honors, with regards to this, we did all the medical examinations, which according to the clarifications include what all examinations were done.
No, counsel, I understand that you have done all the medical examinations, understand that. But unless and until we have the results, what is the purpose of doing a medical examination?
There were 2 medical examinations for the COVID report, which we did. One is PCR and the one is lateral flow test. For one report, we already got the results, which all of the passengers were already negative of. But because the another result for which we could not determine the amount of time it is going to take for the results, We did not await for it because it was unjustifiable for other passengers to wait for it. And because it is also mentioned in the statement of facts that it is sufficient statistically to rule out any risk that the passengers had COVID-19. So it was sufficiently statistically proven that the test which is already done, the lateral flow test, is sufficiently enough to determine whether the person is having a COVID or not. And apart from this, had it been the situation that the claimant has already informed us about her headache, we might have been more precautious about the test and we might have launched it later. But because the claimant was negligent, the claimant breached the contract by not informing the situation we're suffering from. We did not wait for
Counsel, with regard to the headache, it's a chronic illness. It was not actually most probably caused by the COVID-19 variant. It was stated several times in the brief that it is a chronic illness and it might not have been caused in the last 5 days. So, what is the relationship between the chronic illness and a COVID variant which might have been contacted in the 10 days before the launch?
Your Honors, about this headache, if I bifurcate the headache, I can bifurcate this headache into two parts. One is the headache which she usually used to suffer from last 5 years, and one is the headache which suffered in the week of the launch of the flight. So in paragraph number 9, it is already mentioned that during the second week, she began to suffer from a severe headache, which is a change in the medical condition of her situation. She used to have the headache during last 5 years, but during the last week of the flight launch, she suffered a severe headache and also she started feeling tiredness. So even if I ignore the fact that she used to have the 5 years of medical health condition of headache, we might have ignored it. But when a severe headache has come to the role and when she started feeling tiredness, which is according to the clause 5.3 of the agreement, supposed to be told us, which is a change in her medical situation from the date she agreed and from the date the capsule has already launched. There is a change in the medical condition. One, the severe headache. Second, the tiredness, which she did not inform us. So had it been the situation she might have informed us, we might have taken into the consideration. In response to this, again, the clarification number 3 for the medical examination already outlines the symptoms for the COVID, in which it is already included that the headache and the tiredness is a symptom for the new variant of the COVID. So because this change happened during the course of time, she was negligent enough of not informing us about the tiredness and the severe headache she suffered from.
So you agree that your client, didn't make sufficient care?
No, Your Honor, we do not agree. According to us, we followed everything we could follow for the medical conditions. We even followed the recommended practice as recommended practice for the human spaceflight occupant safety. It was only the PCR test for result. PCR test was also done. Only the results were not declared. Had it been the situation that the claimant has told us the situation, we might have waited for 1 more hour. And also for sufficient examination, we did the flow test also, for which she was negative. So according to all the recommended practice for human spaceflight, including clause 4.4.2, 4.4.4, 4.4.5, 4.5.2, which includes the provisions for the emergency situation. Even when we got to know that she is positive during the flight, we managed to help all other remaining passengers so that they do not get infected. We provided masks, we made the situation from the quarantine, we did not allow the claimant to involve in the practices, we aborted the flight early as per the 4.5.2 of the recommended practices. So we were not at all negligent enough in this situation. It was the claimant who was negligent in doing situation. We fulfilled all the conditions, all the requirements we were supposed to fulfill, Your Honors.
Yeah, okay.
Can I move ahead with the next arguments?
Yes,
Yeah,
please.
please.
Yeah, please.
Your Honors, if I speak about the mitigation efforts, it is the defendant who mitigated, and it was the defendant who did everything which they could. It was the Solar Dream company took immediate steps to mitigate the spread of virus, including mask, glove mandates, isolation measures, separate sanitization process. These actions demonstrate our commitment to passenger safety. Similar to the efforts commended in the case of Canadian National Railway Company versus New York Pacific Steam Company, where our carriers mitigation efforts lessens their liability. And it was everything apart, if the claimant might have told about this situation might not have arrived at all in the situations. And again, yes, Your Lordship, Your Honors, any questions?
No.
No, right?
No.
So with regards to the last submission I would like to make is about the damages. The Solar Dream disputes the extent of the claimant's claim damages. The spaceflight agreement outlines a standard refund policy for the various scenarios, including pre-launch cancellation by the passenger and launch cancellation due to the unforeseen circumstances. This policy, along with the limitations on liability for the passengers in illness due to the undisclosed pre-existing condition, will be presented to the court. Furthermore, the agreement may not guarantee specific activities as outlined by Your Honors itself, an alternative content creation opportunity like existent for misclaimant. So Solar Team acted reasonably and in accordance with the industry standards. The claimant's pre-existing condition and the change in her physical condition during the launch hours and during the quarantine period are the primary causes of this whole situation. So Solar respectfully submits that the court dismisses the claimant's claim and award the compensation for damages caused by the breach of agreement, which is 5.1 and 5.2, to the respondent defendant company. And I hereby submit my arguments.
I just have one question, sorry, judges, before we proceed. In your skeleton, you referred to the authority, this is paragraph 5, of Bonito and City and Country Aviation. I think it's an authority that goes back to the Bolam test on medical negligence. So just clarify that authority. How is that relevant to your argument here in relation to the PCR tests?
It is just of a persuasive value to my defendant. It outlines that we as the defendant, we as the company provided everything we could provide to the claimant. We did all emergency situations, we provided all emergency safeguards, we did all medical tests by the qualified doctors. So the case provided in my skeleton arguments is of a persuasive value when a medical negligence is to be considered and when it is not to be considered. So in this present case, the medical negligence by the defendant is not to be considered because the defendant fulfilled all its duty, all its regulations, all its contractual obligations according to the agreed parties and according to the regulations provided.
All right, thank you.
Can I just clarify?
Your Honor.
We understand that you're relying on the claimant's failure to mention her headache.
Your Honor.
Are you saying that if she'd told you about it, that you would not have let her fly, or that you would have cancelled the whole flight?
We would have not let her fly because one patient is already negative. Because of the one patient getting positive result, we cannot compromise with the other 8 passengers. So if she was resulted positive, we might have not allowed her to fly, but we might have allowed other 8 passengers to fly if they were all negative, and we might have made more safety protocols during the flight, and also we might have managed to help the claimant in the proper situation we could have done if she could have informed us earlier.
You see, the reason I ask, isn't it likely, given the incubation period, that the others caught it from her during the quarantine on Earth and not actually at the space station? And so if you'd let them fly, wouldn't you be in the same position?
No, we might have taken the test results for all other passengers also. Only if all other passengers are negative, we might have allowed it. But if any of the passengers are also having a minor symptom, we might have not allowed for the safety of the other passengers. So as a defendant company, as a spaceflight company, I want to assure that my passengers are safe and secured. So even if there is a 1% of symptom with any other passengers, and even if the report is negative, I might have not allowed to fly it because of the safety of the passengers I am taking to the space. Your Honor.
Okay, you still have 2 minutes if you want to conclude your submission.
So my submissions relies on the 5 points only. 1 is the duty of the care and the standard of practice was fulfilled by the client, was fulfilled by the Solar Team company. Second, the claimant's pre-existing condition and the claimant's change in the medical situation during the launch period and during the quarantine period was the cause of this whole problem. Third, there were the complete mitigation efforts done by my client, but there were no efforts done by the claimant in informing this. Fifth is about the damages, that the court should dismiss the claim asked by the claimant. However, the court should accept the claim asked by the respondent in view of the breach of the agreement by the claimant. Thank you. It was great arguing before this honorable court.
Thank you. Thank you. We move now to the senior claimant, Mr. Kikyu.
I guess it is the
Mr.
time for
Kikyu?
the rebuttals.
Sorry?
According to the agenda, we should move to the rebuttals.
Yes, for the
The
Kikyu, for the rebuttal, yes.
Yeah.
Mr. Kikyu? The senior claimant.
Yes, thank you very much. Thank you very much, Your Honors. I was trying to unmute my mic.
So you have 5
May it
minutes
please this- Thank you very much, Your Honors.
for the rebuttal.
May it please this court. Your Honors, once again, I thank you for giving me the opportunity to address this court and rebut the arguments put forward by defense counsel. Your Honors, counsel for the defendants argued that our client was under a duty to disclose her headaches. However, we would like to submit before this court that this duty to disclose must once again be understood within the context of clause 5.2, which stated that passengers were to disclose any medical condition or potential to be medical condition which would hinder their ability to participate in the space flight. Your Honors, once again, we reiterate that our client was not hindered during any of the physical fitness tests conducted by the defendants. Again, the International Headache Society, a global authority on the discussion for headaches, defines chronic headaches as headache episodes per month, 15 or more headache episodes per month for at least 3 months, and chronic headaches was not classified as a headache disorder in the international classification of headache disorders. Therefore, Your Honors, these headaches experienced by our clients that she has lived with for 5 years did not constitute a medical condition which, in contemplation of clause 5.2, she was obligated to disclose. Again, counsel for the defendants argued that they conducted all the necessary examinations which they were mandated to by the regulations for spaceflight occupant safety. However, Your Honors, it is our submission that when the defendants finally decided to conduct the COVID test, the PCR test, which will remind this court, the COVID, which was a global pandemic, was in contemplation by both parties because they said a couple months ago, the COVID virus was in spread and the outbreak was being monitored by everybody. When the defendants finally decided to conduct this COVID test on the day of takeoff, Your Honors, they should have waited for the test results to come out, as it is our submission that the basis of a test is to ascertain the medical status of a passenger in contemplation of the space flight. Your Honors, where they conducted this test, they owe the duty of care to wait for those results and assess those results in contemplation of passengers' fitness for space travel. Again, Your Honors, counsel for the defendants argued that they adhered with safety regulations by attempting to mitigate the potential outbreak of the COVID virus. Your Honors, the statement of facts corroborates our claim that their mitigation methods and safety protocols were grossly deficient, as our clients not only contacted the COVID virus during the quarantine exercise, the Moot problem also shows that the virus spread amongst all passengers and crew, leading them to even abort the space mission and return back to Earth. Therefore, proving that even though the defendants implemented mitigation methods, those methods were insufficient, and our clients have suffered harm and should be compensated for that harm. Again, Your Honors, this court, the DIFC Court of First Instance, stated in the case of Amira Foods International versus IDBI Bank Limited and others, that a party cannot rely on his or her own breach to obtain a benefit under a contract. Your Honors, the defendants breached the contract by the many instances cited by the claimant, and they have obtained numerous benefits under the contract because our client paid for this contract and she was unable to get anything out of it. Again, Your Honors, the courts, the DIFC Small Claims Tribunal in Liberty versus Land Real Estate Broker and others, citations 2020 DIFC Small Claims Tribunal 128, stated that where there exists an event making performance impossible, restitution to the original status should be achieved. Your Honors, we've been able to show this court that our client indeed was owed a duty of care. That duty of care was breached. And we've also been able to show this court that the defendant owed certain obligations to our clients, and those obligations were not met, and our client has suffered consequent damage and loss, some of which we have front-loaded before this court in the documents in the chat box, the rest of which we have outlined in our arguments. Therefore, Your Honor, it is our submission that the claimant must be compensated for the numerous instances of breach suffered by her and the breach of the duty of care by the defendant to the claimant. On this, Your Honors, we urge this honorable court to indeed hold our claim for $15 million in damages due to the severity of all these breaches, discountenance the defense put forward by the defense counsel.
Meanwhile, sorry. Meanwhile, the agreement limit the compensation, the amount in $1 million.
Sorry,
However,
Your Honor.
The agreement
Yes, Your Honor.
the agreement limits the amount in $1 million.
Oh, thank you very much,
However,
Your
you
Honor.
asked $50 million.
Thank you very much, Your Honor. Your Honor, in response to your question, Lord Denning posited in the Castles Limited versus Wallace case that exemption clauses, no matter how widely expressed, should not avail a defendant where they are guilty of a breach of contract which goes to the root of the contract. Your Honors, if the court decides to uphold the defense of the defendant stating that there was an exclusion clause, it will set a terrible precedent before this court wherein parties to a contract which are the superior party would include exclusion clauses like this, go ahead to breach the contract and rely on those exclusion clauses to the detriment of the lesser party.
Sorry, but your time is finished.
Thank you very much,
Thank you,
Your Honor.
Okay, we'll move now to the senior defender for the rebuttal.
Your Honors. Your Honors, thank you so much for providing me this opportunity and making the response to the rebuttals made by my co-counsel. In response to the rebuttals made by my counsel, I would like to make submissions firstly with regards to the headache she's suffering from. So again, making the same submission about the headache, there can be two headaches which I can divide in this situation. One is the headache which she is already suffering from last 5 years, and one is the headache change, the severe headache which got changed during the quarantine period. So according to the medical evaluation agreement 5, agreement clause 5, 5.2 and 5.3, if there is any change in the medical situation, okay, if I accept that the headache has been continuously for 5 years, but this headache is now a severe headache, and it is completely as per the clarification, the symptoms include the headache. It does not include the chronic headache or the severe headache. The symptoms according to the Health Organization for the Vulcan variant, which was described on 15th February 2024, the simple symptom is the headache. So it was the duty of the claimant to disclose the fact that she has got a severe headache. Again, in response to the COVID test about the PCR test and the flow test, I would like to make submission that it was the time when the force measure was in the force act of God. We did everything we could did which was possible. We did flow test, and because of the limitations, because of the limited capacity of the test we could do the PCR test lately. Henceforth, we relied on the suggestions given by the medical professional, and we did give the green signal according.
Counsel, as per the agreement, the testing should have been done by a doctor, right? But instead, the testing was done by a nurse. Is there any particular reason for that?
Your Honor, there are two things. There were two tests done. One was the initial examination, which included the test conducted by the doctor, and second is the PCR test and the flow test, which was done by the nurse. So in response to this, if I bring your Honor's kind attention to the clarification number 3 of the medical examination, it already describes the test conducted by the doctor and the test conducted by the nurse. So in that test conducted by doctor, it already includes a physical examination by the nurse. So my point is, when a nurse is doing, it is under the examination of the doctor. So this test of PCR and the flow test of to determine the COVID was not so specific that it should have been only done by the doctors, but it can also be done under the guidance of the medical professional. So according to the clarification, we had the Dr. Leona McQuay, the retired chief medical officer from the NASA. So the main medical examination was done by the professional doctor. However, just a physical examination was done by the nurse, which is the present case hired for the contractual period. With regards to the mitigation efforts, my counsel, the counsel for the claimant brings the point is, if again I would like your honor's attention to the fact sheet of paragraph number 12. It says that the captain and the crew member to put in place whatever measures they could prevent further transmission of the variant. They asked passengers to wear masks and gloves for the duration of the retreat, and the mediation and the yoga session went ahead without Artemis. So this shows that the claimant, so the defendant in the present case, tried their best to mitigate the efforts, and they were capable enough to handle the situations. With regards to the breach of the contract, I would like to make the submission again that it is a breach of the contract by the claimant by not disclosing the relevant information which supposed to inform, and it is not the defendant which have breached the contract. In response to this, I would like your honor's attention to the judgment of Ms. Selama Dwela versus Damak Park Towers. It is a claim number CA009-2020 of DIFC codes, which describes about the causation that to establish the liability under this law, a claimant must show that for the defendant's conduct, he should have not suffered loss, that the defendant's conduct was a substantial cause of his loss. So in my present case, it was the claimant's act which caused this act, and it was not the act of the defendant which caused the whole problem. So henceforth, I submit my arguments with the rebuttals also, and it was great arguing before the honorable court.
Okay, thank you for your respecting the time, and we move now to the junior claimant. Who is the junior claimant, please?
Sorry, Your Honor, if you pleases,
The junior
I think the
defendant.
order, if you pleases, the order of arguments will see the junior defendants present their counterclaim.
Yeah. It is junior
Thank you.
defendant to start.
Thank you very much, Your Honor.
So may I begin? If I'm audible and visible, can you please confirm?
Yes, I
you
can
are.
hear you.
Yeah, yeah.
May it please the court, I'm part of the team GNLU, appearing on behalf of defendant in the case before the court today. Over the course of the next 17 minutes, I will be presenting the submissions of the defendant pertaining to the counterclaim. Ms. Ashrothia is liable to Solar Dream for breach of contract since she failed to disclose the medical conditions mandated by clause 5.2, 5.3 and 5.5. To support the contention, the counsel shall be presenting three submissions. First, headaches constitute a potential medical illness that can affect the participant's fitness to participate in the flight. Second, not informing about the changes in the condition and not promptly reporting her worsening condition constitutes a breach of contract. Third, Artemis is liable for misrepresentation for not full disclosure of the facts. If the judges have no preliminary questions, then may I begin with the first submission?
Yes, please.
Yes.
Thank you. Firstly, headaches are recognized as a potential medical illness that is capable of affecting a participant's fitness to participate in a flight. Artemis, by failing to disclose her long-standing issues of headaches, by long-standing it is 5 years long-standing, she breached clause 5.2 of the agreement. To support this, first, I'll be presenting three things. First, that the US branch of Social Security also recognizes headaches as a disorders and make them as a medically determinable impairment that can significantly limit an individual's physical and mental ability to engage in basic activities. Second, as the WHO report of Global Health Estimates 2019, headaches were ranked as the third leading cause of impairment, which is followed by stroke and dementia. Third, the Medical and Family Act also recognizes migraines as a serious health condition and recognizes a needs to provide specific provisions for them. These contentions are also supported by judgments which are persuasive in their value. That is, first, Alexander versus Beijing Co. In this case, the case highlighted the significance of headaches in the workplace. In workplace, I like to point out that if
Counsel, where is this case from? Counsel, where is this case from?
if I go to the citations, I'll just need a minute. Alexander and Bishankur. The citations. It's a US case, as far as I'm informed.
Okay, please carry on.
Thank you. The second case is Patton versus Paris Henry County Medical case. The case also highlighted the impact of headaches and required them and how they can impact workplace fitness. As proven by the previous mentioned statements, the headaches form a serious medical condition that can impair a person to participate in the flight. If a headache can impair a person and affect their ability in a workplace environment, it has the possibility of affecting a person's fitness in a space flight, that is a different degree of higher order. Second, moving on to my second argument, Artemis' condition started worsening during the pre-flight quarantine period, which she failed to report, breaching clause 5.3. This also contravenes the obligation imposed by clause 5.5. It is clear from the facts that during the second week only, she began suffering from a chronic headache that was increased intensity and also included feeling of tiredness, which continued till the date of the launch. That is a slight larger period for a headache to continue and some other symptoms to also occur. The feeling of tiredness.
Counsel, you were explaining that headache is considered as one of a very serious illness as per the WHO. So, in your pre-medical examination, did you put any questions regarding headache to the claimant as to whether she has, because as per your argument, it is one of the very serious illness as per WHO. So, have you put this question directly to the claimant during the medical examination?
Yes, so much applied. So, what we are claiming is per se headaches are not a serious illness, but the headaches that Artemis suffered, that is 5 years persistent illness, that is one of the conditions that can impact her ability for a flight. That is mandated by in a spaceflight. Of course, if they're traveling to outer space, they are required some changes by the conditions, meteorological conditions, environment conditions. For that, headaches are an important condition that needed to be considered, and that Artemis had the duty. Since in our world there are a lot of illness and we can't make a list and ask whether you have this conditions. It was the liability was on Artemis to tell us that she's suffering from a thing for the past 5 years that can impact us.
Okay, please carry on.
Thank you. Moving forward, it is clear that she suffered from headaches and symptoms of tiredness. Second, this constitute a negligent attitude on part of Artemis, where she was contractually bound to inform the changes in her condition, which amounts to breach. Lastly, Artemis misrepresented her exact state and knowingly did not disclose the facts. Her failure to disclose them when explicitly stated to provide medical conditions or symptoms that may affect the fitness for the space travel. This omission led Solar Dream to believe that Artemis was fit for the flight when she was actually not. Artemis cannot be said to be also acted in good faith when she did not disclose her actual condition, because Artemis knew that this journey has the possibility to help us in her medical illness and also contribute increasingly to her popularity and sales. Knowing all the benefits of the space travel and the advantages that Artemis can receive, she deliberately did not disclose her illness. She also feared that if she did, the authorities would not allow her to participate in the agreement. This shows that she knew the intensity of the headache, because if she would have had a minor headache, she would not have feared the fact. But the fact that she feared it, which is shown in the facts, this shows that she knew of the capacity and the intensity of the headaches, which have the capacity to disbar her from the space flight. This shows that Miss Hastrosia did not act in good faith, and the non-disclosure of chronic headaches during the evaluation process constitute a misrepresentations and thereby breaching the contract.
Okay.
I'm done with my arguments. Now I'll be moving on with the prayer if the judges have no more further questions.
Can you help us with this? Presumably you're not suggesting that she picked up the virus whilst in your quarantine. Presumably you want to say that she picked it up before she came in. Why didn't you test her before she came in and test everybody every day? Because isn't the most likely thing that even if she brought it in from outside, didn't she transmit it to all the others before they even got onto the shuttle?
Much applied, sir. In regard to this answer, I like to say that Artemis did not contract it during the quarantine period, because in the quarantine period, she is presumed to have been carefully seen by the Solar Dream Authority. And if it would have been, because COVID-19 virus increases, and especially the Vulcan variant increases in its intensity. If she would have contracted in the quarantine period, the symptoms would have increased than a headache or the feeling of tiredness. We are stating that she may have contracted the virus during the New York layover time, that is after the quarantine period ended and when she traveled. After that, we did conduct the two tests, lateral test and the PCR test.
Sorry, the question I'm asking is that if you only test her at the end of the quarantine period, then by that stage, she had already transmitted the virus to the other passengers, hadn't she?
Since the facts are silent on what all the things are observed during the quarantine periods, we presume that we would have seen all the things. And if any person, by seeing their symptoms, showed that they are able or may contract the virus, we would have tested them. Seeing that no symptoms was seen during the quarantine period, that is a long period, we did not conduct any tests.
Just following from my colleague's very helpful question. So in your skeleton argument, and you're going to deal with the prayer in a moment anyway, but you've mentioned, and your colleague has mentioned, the industry standard when it comes to screening. So I think this term has been used by yourself and your colleague, the industry standard when it comes to screening procedures. I mean, this is an expensive ticket, isn't it? This is an expensive flight. There's quite a lot of money involved. Yes. So just coming back to my learned friend's question, what do you say about the absence of having a proper PCR test procedure in place, even on a daily basis, to make sure that all passengers are properly screened before they can go on board?
So we recognize that the ticket was quite expensive, that is 10 million. And we did conduct a series of tests that can be seen from the clarifications. All the tests that we thought, since the people who were participating went for a 1 week span of time, we did all the necessary conditions, that is ECG for heart attacks and other things that we thought a patient might have and which could have been a problem in the 1 week period. Since this was a force majeure or an act of God, and COVID-19 variant is relatively new, and we also know from our daily activities that PCR test does not usually take that much time. Since the Vulcan variant, it came very fast and it increased in its intensity. That's why we had to conduct PCR test at the time when it was available. Previous to that, there was no such need or conditions that PCR tests would have been mandated, or else we would have necessarily taken it into consideration.
I mean, the claimant might argue that he took a chance by just relying on lateral flow tests and, didn't quite turn your mind to the importance of doing proper PCR tests. That's what the claimant's argument is, I think.
Yes. So we relied on lateral flow tests. As far, we also relied on the quarantine. It was a large process of whole screening and testing. We presumed that if none of the problems occurred, and we also put a reliance by our agreement also on the patients, on the people, that if they are experiencing any symptoms, they have the liability to come and tell us. It is not reasonable for us to go and contact every single person and do every single test. We recognize that there might be a mistake on our part, but that mistake was corroborated by the nurse and the doctor's own on their own discretion that may not be necessary. If Artemis would have told us that she's experiencing symptoms such as tiredness, most importantly, and headaches, then we would have necessarily taken the test a bit earlier. But since the meteorological conditions and everything mandated the flight to take off, and for one person, we could not have stopped the flight. That's why we had to move forward.
Thank you.
It was a pleasure. It was an honor.
Counsel,
yes, sir.
Counsel, you have actually made a claim of 5 million. What is the reasoning for the 5 million claim? Where did this value come from?
So, as far as where did this value come from, that proper chart to us is not given by the facts, but seeing from the fact sheets and how much I can reasonably see, the 5 million, since it is written in the fact sheet that the reputational loss, we are not suing for slander, but still we are suing in order, we want the damages because there is reputation loss that is directly affecting our future earnings. People have cancelled their flight tickets and there have been lot of losses on our part. Since that much mistake was not done in Solar Dreams part, we want damages to be paid to us.
Okay.
Yes.
Okay, thank you. Thank you so much. Very much. We move now to the junior claimant. Who is the junior claimant, please? Hi, the claimants. I think there is no claimant. Mr. Kikayo.
I guess in the chat box they initially mentioned that they could not hear the argument. So again, the problem might be there that they're not able to hear us.
Yes. I'm sorry, Your Honors. We have been having a break in transmission.
Present yourself, please.
Take your time and get comfortable.
The counterclaim. Your Honors, it's a submission that my client followed all protocols and guidelines provided by the counterclaimant in the
Your name, please. Your name.
contract, and their actions did not contribute to the contract breach as claimed by the counterclaimant. Your Honor, my submission will be. Your Honor, Your Honors, I'm sorry. Were you about to say something?
No, I don't think so.
Can I proceed, Your Honors?
Yes.
I think there's a time
Can I
lag
proceed,
on.
Your Honors?
Yeah.
I think she had a time lag on her transmission, so she was hearing things
Yeah.
that were said a few seconds later.
Your Honors, I'm sorry for the break in transmission as I just keep getting logged out of the site.
Okay,
Your
we
Honors,
can
may I
hear
proceed?
you. So continue. We can hear you now. Yeah.
Okay,
Carry
yes.
on.
Okay.
Okay. Your Honors, my submissions will be expatiated under 2 points. Number one, payment of compliance of contractual obligation, and number two, contributory negligence. Your Honors, to my first submission, my client fully complied with her contractual obligations brought forth by the agreement. Therefore, she cannot be liable for breach of contract as claimed by the counterclaimant. My client acted in accordance with all her obligations set forth in the agreement by first making the required payment of $7.5 million for the space flight ticket, with the promising intent of completing the remaining $2.5 million for the ticket. My client also submitted herself to the physical examinations, medical evaluations, and variety of tests conducted by the counterclaimant, Solagym Incorporated. Yes.
When you are logged back in, I will need you to speak with more conviction. You are speaking with conviction until somebody says you should calm down.
I am sorry once again as I just got logged out of the site. I have no idea why it keeps logging me out. You know, before I break in transmission, I was addressing this court on my client's contractual obligations which she fulfilled. My client also submitted herself to the COVID-19 test, which was conducted by Solagym Incorporated. She also waited for the results of this test, but proceeded for departure when she was authorized to do so by the counterclaimant. Therefore, Your Honors, from the facts stated above, it should be noted that my client fulfilled all her obligations to the contract. Therefore, she cannot be said to be liable for breach of contract. My client should be absolved of all her liability as a breach solely originated from the counterclaimant's inability to fulfill their primary contractual obligations. Your Honors, on my second submission, we submit that my client in no way contributed to the non-fulfillment of the contract. It's evidence that my client fulfilled all her obligations outlined in the contract, and any failure to fulfill the contract can be attributed solely to the actions of the counterclaimant. Your Honors, this
Counsel,
allegation. Yes, Your
counsel.
Honors.
Yeah,
Yes, Your
counsel,
Honors.
you just mentioned that you have actually done everything required as per the contract. But as per the
Yes.
facts, or as per the contract, it says that if there is any change of any medical situation or anything, you are supposed to or you are expected to inform the solar dream. But from the facts, it's clear that you have purposefully decided not to mention the same to solar dream. So is then that while a violation of the contract?
Thank you very much, Your Honor, for that question. Your Honor, this obligation was outlined in clause 5.2 of the agreement, where my it stated that the passengers submit to their it stated that the passengers declare and represent that to the best of their knowledge, they are not aware of any medical condition or symptoms of a potential medical condition that may affect their ability to participate in the space flight. Your Honor, from this clause, my client, the chronic headaches by my clients were in no way affected her ability to participate in the space travel. Your Honor,
Council, I was not discussing about 5.2. I was discussing about 5.3 when there is a change in the medical condition.
oh,
You were explaining about 5.2. I was asking about 5.3.
okay. Yes, Your Honor. Sorry for the confusion. Your Honor, the change in Your Honor, I presume you are referring to the severe headaches which my client started occurring at 2 weeks after the quarantine. Your Honor, these severe headaches my client occurred was stated in the contract that it was uncommon to my client. Was stated in the facts of the case that this severe headache was uncommon to my client. Therefore, my client did not picture this severe headache as she did not picture this severe headache as something that will hinder her participation in the space flight. It should also be noted in the facts of this case that the severe headache also disappeared before the space flight, Your Honor. So, Your Honor, this severe headache, my client firmly believes that this severe headache in no way contributed to her participation in the space flight, Your Honor. Your Honor, may I proceed with my submissions?
Yes. Yeah, please, please.
Your Honor, I proceed with my submissions.
Yeah, please proceed.
Your Honor, my second submission, we submit that my client in no way contributed to the non-fulfillment of the contract. It's evident that my client fulfilled all her obligations outlined in the contract, and any failure to fulfill the contract can be attributed solely to the actions of the counterclaimant. Your Honor, these allegations on non-fulfillment is based on the misguided belief that my client made no disclosure of her chronic headaches as provided in I was being logged out from the site once again. Your Honor, to your question, it should be noted that the severe headaches experienced by my client was common to her. And in the next paragraph, in the circumstances of this case, it was noted that the headaches also subdued to a mild headache. So, Your Honor, these headaches were in no way hindered her participation in the space flight. Your Honor, may I proceed?
Yeah, please proceed. Yeah.
Your Honors, the allegations of non-fulfillment by the counterclaimant is based on the misguided belief that my client had made no disclose of her chronic headaches, as provided in clause 5.2 of the agreement. My client had no duty to disclose her chronic headaches because she firmly believed that these chronic headaches were not a medical condition or symptoms of a potential medical condition capable of interfering with her participation in the space flight. Flowing from the circumstances of this case, I would like to clarify the misguided provisions of clause 5.2 of the space flight agreement, which stated that all passengers declare and represent that to the best of their knowledge and belief, they are not aware of any medical condition or symptoms of a potential medical condition that may affect their ability to participate in the space flight. It's important to understand that while these chronic headaches can be a standalone medical condition, they are not indicative of an underlying medical issue. You know, these chronic headaches can be caused by a variety of factors such as stress, tension, poor posture, or even environmental triggers, which indicate that they may not indicate a serious medical issue. The International Headache Society, a global authority on the discussion of headache, defines chronic daily headache (CDH) as 15 or more headache episodes per month for at least 3 months. Chronic headaches, Your Honor, is not an official class in the International Classification of Headache Disorders, ICHD. It's crucial to recognize that my client has had these chronic headaches for the past 5 years, and they have in no way hindered my client's participation in any social or physical activities, therefore failing to fall within the contemplation of clause 5.2 of the agreement. The fitness for space flight, Your Honor, is determined by a comprehensive assessment of an individual's physical and psychological health. If an individual with chronic headaches is medically tested and proven physically and psychologically healthy for space travel, your Honor, the chronic headaches do not pose a significant threat to this individual's ability to participate in that space travel. From the circumstances of this case, Your Honor, my client undergoes medical and physical examinations carried out by qualified medical professionals from the counterclaimant, which she gracefully passed, therefore proving once again that my client was fit and ready to participate in this space flight at the time of initial testing on December 12, 2023. It's also imperative to note that the damage suffered by Solar Dream is too remote to the alleged breach of contract by my client. It's an established principle in law that where someone has suffered a wrong, there should be a corresponding remedy to that wrong, as captured under the Latin maxim of ubi jus ibi remedium. Your Honor, this principle is extended to breach of contracts. Can you hear me, Your Honors? Your Honors, I'm sorry for the break in transmission as I was logged out once again.
Okay, don't worry, don't worry.
Your Honor, the principle of ubi jus ubi remedium is extended to breach of contract. As well, there is a breach of contract, there is a remedy at law for this breach, the most common remedy being damages. The general principle for remoteness to damages was formulated by Anderson B. in the case of Haley versus Bazadale, citations 1854, 9EX 341, where the court stated inter alia that the loss is only recoverable if it was in the contemplation of the parties.
There was quite an echo.
The
Council.
contemplation, you all know, that Solardim has suffered a significant loss. It's not a direct consequence of my client's failure to disclose her chronic headaches. The principle of remoteness to damages serves as a fundamental tenet in contract law, limiting the scope of liability to losses that are reasonably foreseeable. I'm sorry, Your Honor, in transmission. Your Honor, as I was saying, the principle of ubi jus ubi remedium is extended to breach of contract. As well as a breach of contract, there's a remedy at law for that breach. You know, the contemplation that Solardim has suffered a significant loss is not a direct consequence of my client.
Sorry to interrupt everyone. Are there any issues with respect to the audio?
Yes, I mean we've had echo issues. I think. I mean the claimant's internet connection seems pretty
Yes.
bad.
Otherwise, I'm audible perfectly fine, right?
I think multiple.
As I was saying, Your Honor, the result of the breach was the counterclaimant's failure to implement proper medical safety protocols to prevent the widespread of such diseases, such as launching without obtaining the results of the PCR test. According to Article 113 of the DIFC contract law, it states that in the claim for damages, the non-performing party is only liable for harm which it foresaw or could reasonably have foreseen at the time of conclusion of the contract as being likely to result from the non-performance of the contract. Therefore, the breakout of the COVID-19 virus ought to have been a reasonable contemplation that the claimants should have run the appropriate test to ascertain the carrier for this virus before the quarantine on the 1st of February 2023. Your Honor, the law seeks to prevent imposition of disproportionate or unforeseeable liabilities in contracting parties. Therefore, allowing remoteness to damages to be attributed to the breach of contract will undermine the principle and create uncertainty in commercial agreements. In conclusion, my client's actions and behavior. In conclusion, Your Honor, my client's actions and behavior in relation to the contract with the counterclaimant demonstrate her adherence to the agreed terms and her intent to fulfill her obligations. As such, she is not liable for breach of contract, Your Honor. The failure of the contract's successful execution solely lies with the counterclaimant's inability to ensure by the counterclaimant, including the $5 million in claim for damages, as the defendant is not liable for breach of contract. Thank you, Your Honor.
Thank you. And we should move now to the junior defender for the rebuttal.
I'll be stating rebuttals. I'll be pointing out a few points that
Your
the
Honor,
claimant
can you hear me, Your Honor?
No, super outside. The junior defender, yes. You have it's your floor.
Yes. as mentioned by the claimant, that the headaches, she mentioned that the headaches are severe in nature, and by the term severe, we understand that they are not nominal headaches. They have a higher intensity, which needed to be told to Solar Dream in order to move further with any examination. Moreover, that according to 5.3 and 5.5 of the clauses, that there was an changes in her condition. There was not only headaches were not the only symptom available. There was also the symptom of tiredness, both of which are one of the symptoms that are mentioned by the clarifications for COVID-19 virus. She should have told, Artemis was mandated to tell us the changing conditions. Moreover, as told by the claimant, that the headache's underlying cause may be stress or tension, but to point out that 5 years long standing headaches cannot be only attributed to stress or tension, even if they are due to environmental condition. Then moreover, they should have been told to us, because as space flight, in a space flight, moving to another outer space would have more environmental changes, would have led to more severe headaches. Whatever the main cause of the headaches was, it should have been told to us, because it was not normal headaches. Normal headaches last for few days, not years. As far as contributory negligence is considered, there was negligence mostly on behalf of Artemis, where she did not inform and breached the contracts. Solar Dream did whatever it could have due to the force majeure and act of God. It consisted with the industry standard as previously stated. They solely breached the contract and did not abide by the rules. That's it.
Okay, thank you. Still have 2 minutes. We move now to the junior claimant for the rebuttal. Junior claimant, please. Do you hear me?
You know?
Yes.
You know, on my rebuttal,
yes,
the counter-claimants argued that headaches are a very serious condition which impacts the passenger's ability to engage in space flights. However, it's a submission that by the definition given by the International Headache Society, headaches are not a medical condition, and our client passed all the counter-claimants' fitness tests. The counter-claimant also argued that our client falsely misrepresented facts by her non-disclosure of the headaches. However, the space tourism contract did not explicitly require the disclosure of all general symptoms, but medical symptoms that may affect her ability to participate in the space flight. Your Honor, her client cannot be held for a higher standard of disclosure than what was reasonably expected based on the terms of the contract. The counter-claimants have not been able to establish causation in their claim, because they have not been able to show that our client's non-disclosure was the reason for the discharge of the contract. The contract was discharged by the outbreak of the COVID-19 virus, which happened due to the negligence of the counter-claimants in their failure to wait for the PCR test. Your Honor, the counter-claimant also argued negligence for my clients. Your Honor, however, in ascertaining but not conceding, there was negligence. The counter-claimant was contributory negligence by failing to show duty of care, in their inability to present the results of the PCR test before takeoff. Thank you, Your Honor.
Thank you. Thank you. Okay.
Your Honors, should we expect for the feedbacks, or are the rounds over?
Yeah, you still have 2 minutes.
No, I mean the rounds are over for everyone. But in the earlier rounds, we were given feedbacks from the judges. So will we be getting feedbacks in these rounds, or should we just end the session?
Yeah. We will give you the feedback after the deliberation.
Yes.
Yes.
So
Okay.
if it pleases the court, Your Honor, I'd like to speak.
My colleagues, please move to the judge rooms.
Oh, sorry, Your Honor, if it pleases the court, I would like to state as a general concern But we sincerely apologize for our network problems. We are operating with 4 laptops and we have been alternating between all four and we keep getting kicked out. This system has a disabled camera. All 3 other systems with cameras have refused to log in. We are currently trying as we speak. So that is the reason for our constant coming in and out of the next session. So we sincerely apologize. Thank you very much.
Thank you.
I have
Mr. Lee Chama and Shishir Billa, we should move to the judge's room.
the
Okay?
judge room's link is put on the chat. Please
Okay, thank
join the
you.
link mentioned on the chat.
Okay, thank you.
Okay.
Hello. Can you hear me? Sorry, I wasn't able to find the room, but I think I'm in.
Yes, I can hear you. So, in order to join the judges breakout room, you have to click on the link that is put on chat. You'll see a
Yeah.
link on the chat.
I think I'm in. I think we're all in, aren't we? Am I? Can you see and hear me? I think I'm
Yeah,
in.
I can see and hear you,
Brilliant.
sir.
Okay, great. Thank you.
But you'll have to leave the scope and join the link.
We can see you. I think we've automatically left it. I think.
So I think Lee is going to join, or
Yeah, it should do. Setu, I'm happy to start just by making one or two
please.
observations. Then I'll.
Yes, please.
Okay. Well, so if everyone can hear and see me, well done to all of you. I really enjoyed that. Very well presented from both sides. A very interesting case, and just a couple of observations without giving too much away. I think all of you, one thing that's always very tempting when you introduce a case to a judge or judges, introduction I think is very important. So, we here in the legal confirm this, that judges like it when you introduce your opening submission by, first of all, you give your name and also the name of your junior colleague, but also it's very helpful to address who it is representing the other side. So, my name is X, my learned friend Miss Y will be dealing with the second half of the submissions, and my learned friends from the other side are X and Y. And I think that always, it's a very good opening to have, always, to introduce not only yourselves, but your opponents as well. But the second observation I have for all of you is, I know it's very difficult, and I fall into this same mistake myself in court. Try and slow down. There are a lot of judges who will say, pause, I'm writing everything. Because remember, the judges are writing everything down. And if you go off sometimes like a steam train, it becomes very difficult for judges to keep up. And a lot of experienced barristers and solicitors, fall into this trap because you're so passionate about the points you want to make that you sometimes forget that the other person is writing everything down. So there are some judges who are really, really nice that will say, just slow down. But there are others who will be a lot less forgiving and, will scold. So just remember to pace your submissions very slowly. Make sure that you're keeping an eye on the judge's pen. And if he or she is scribbling away, just pause a little bit to make sure he or she keeps up. But yeah, I thought the skeleton arguments were very helpful. The presentation of both sides was very helpful. So really good. I really enjoyed hearing everyone's advocacy. Thank you.
Okay, thank you. It's your floor, Mr. Satu.
Hi, all of you. Excellent rounds from both sides. Okay, it was really interesting. Interesting, actually, facts. Quite a lot of things in the facts, but there are a few very important areas to be picked up to argue on. Even though there are a lot of facts, only there are a few areas that need to be picked up. Okay, excellent from both sides on that. Interesting to see that you are quite thorough with the facts, which is very important because facts makes most of the case. Even though authoritative and legal cases are important, but facts is very important to understand so that you know exactly what you're arguing about. Make sure that whenever you're actually quoting a case laws or anything, you really understand the case law. If make sure that you read the case law to understand what portion of the case law you're actually arguing or quoting before the court. A lot of times the judges might ask you why you're actually quoting this case or which part of the case law or is you're arguing about. So you should be able to explain that before the court to clearly say that why you have picked up that specific case to argue or quote in that particular point. Okay, it was excellent, all of you. Best of luck for all of you. Okay.
Okay, thank you. Mr. Lee, it's your floor.
I definitely echo what's been said before about pace. I think, rather like now, if you just slow down, it's very easy to draw people in and help make them listen to you. The other thing that's very important is that if you speak very fast, it's not just the judge might not pick everything up, but when you've then got a problem, it becomes very obvious. If you're asked a question, you find it difficult to answer and you have to then stop. Whereas if you've got just a pace that's like this, no one really knows what you're thinking, and that can sometimes be useful. The second thing I'd say is I think that structure is really important. I think Suprabha did that particularly well. You can just say, I'm going to make 3 points. The first is this, the second is that, the third is this. And that's always useful. It's so useful for the judges, and it's useful for you because it keeps you on track. If you're asked a question, you can think, well, hang on, is this relevant to one of my 3 points or is this a new point? And then the other thing as well, I thought you all answered the questions you were asked really, really well. You know, some of them were pretty difficult and pretty testing, and I thought they were absolutely excellent. And then just the final thing, you know, what happened with the final speaker, and it can happen to anybody, you know, when you've got transmission problems, and it does happen in real remote court hearings, and all you can do is try to deal with it as best you can, which is what was done today. But all I would say is that, you know, if you're doing it for real, you would get more time. It's just unfortunate in a competition, it's not always geared up for that. But, you know, don't let that worry you or put you off. It was really dealt with brilliantly, and that is the way to do it.
Okay, thank you, Mr. Lee. Finally, okay. So you are excellent, firstly, and I hope you all the best. Secondly, as you know, we could not publish the result now, and you received it in the evening, inshallah. Okay, go ahead. Nice to meet you, Mr. Lee. Nice to meet you, Mr. Sato.
Nice to meet all of you.
Okay.
Thank you.
Bye.
Bye-bye.
Thank you everyone for the feedback, and thank you for judging us.
Okay, goodbye. Nice to meet you.
Thank you. Bye.
Thank you.
Bye.